Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have 0 viewers right now, but I have about an hour. It's President's Day, and I didn't schedule this in advance, but I wanted to get something up, and I decided to go live because I'm going to answer some questions from emails, and then if somebody hops in the chat, I'll try to answer their questions as well. So I'm going to get started with a question from the email here. Let's see. I'm trying to find a good question to answer. Going through some questions. We have quite a backlog. I have a backlog of 245 emails right now in the YouTube channel, so I'm trying to find a good question here. Okay, so YouTube user Leah Sim Arxkio CT8SE asks, how unusual is it for a position statement to not be required, and in what instances would it not be required? Okay, so Leah, I'm assuming that you were dealing with the Equal Employment Opportunity Commission, and you're asking me how often the Equal Employment Opportunity Commission would not require a position statement from the employer. So I guess the first thing I'll say is position statements never required. Like if an employer decides to just ignore the EEOC, the Equal Employment Opportunity Commission, they can do that. And the result of that is generally 99.9% of the time going to be that the EEOC just issues a right to sue letter to the employee, and then the employee can take that right to sue letter and go on to federal court if they want. Now, this is rare, but employers can just choose not to put in a position statement. Another thing that will happen is sometimes people file junk claims or irrelevant claims with the EEOC. Like claims, like if you go to the EEOC and you're like, I'm not getting paid my overtime. The EEOC is like, yeah, that's not what we do. Or people go and be like, I'm being bullied in the workplace. And it's like, well, are you being bullied because of some kind of discrimination or sexual harassment? Because if that's not what's going on, the EEOC doesn't care about that. The EEOC deals with workplace discrimination and workplace sexual harassment, right? So that's all they deal with. If you file something that they just don't care about, they're like, yeah, there's not a need for a position statement because this thing you filed is meaningless to our agency. It's not what we do. That'll happen as well. All right, let's what we got? Where's the live stream? Let me find it here. Oh, whoa, we got people in the chat. We got 24 people already. My gosh, we got 24 people in chat. I'll start answering chat. Whoa, Rebecca Balthus sending us $3. My goodness, with a very cute Chiba Inu puppy dancing around. I will start answering questions from chat. Everybody, I'm going to be on until 1 p.m. Big news. I decided to trade in my Ford Lightning, my 2022 Ford Lightning electric truck. And I'm going to be getting a 2025. I'm going to sound like an old man when I say this, or like deceased Tony Soprano. I'm going to be getting a 2025 Cadillac Escalade IQ, an electric Escalade. I'm very excited for it. Very, very excited. So I got to leave at 1 to go do that. But all right, let me get the chat. Lance Daring says, hello, Lance. Rebecca Balda says, hello, counsel. Nice to see you. Good to see you as well, Rebecca. Thank you for the donation. Don't have to do that, but I know you're doing it for the algorithm, so thank you so much. And everybody else, I'll note that we have 22 people watching, but only 4 likes in the stream. Remember, when you like the stream, it's how the algorithm sees the channel, and it does help us to help more people just like you. So it is free to like the channel or to like the stream. Suzanne 1990 says, good morning. I received an EEOC letter letting me know my case is appropriate for early mediation. When should I expect the employer to make the decision? Probably 2 to 3 weeks. YouTube user Shamika says, at a 26F conference, what are the main things talked about? All right. Let me get you a more. Okay. 26F conference, basically you're talking about discovery. So that you're going to talk about your discovery production, what is not. They're going to things that you might set a schedule. There might be some fights about what should and should not be produced, things of that nature. Bambito Danon, YouTube user Bambito Danon says, and I'm coughing so much because I just had coffee like an idiot before I went live. Good afternoon, Vince. Is there such a thing as a discrimination Rico? If so, what is needed to prove it? Okay, so there's not discrimination Rico, but there is civil Rico. So we'll give a. Actually, there might be a video on the channel about civil Rico. But Bambito Danon, here's what I'll say. Hit up the channel search function, check for civil Rico. If we don't have any videos on that, comment on a video, and I'll make you kind of a more involved video about civil Rico and how we use it in the realm of discrimination. It's a bit novel the way we've done it, and it's had mixed results, but it can, in certain situations, be a useful tool. Essentially, I'll give the 20-second version here. So criminal Rico is like essentially conspiracy. Like there's a conspiracy to commit a crime, and the U.S. government uses it to like get criminal charges against people that when they can't prove that people actually did any actual crime, but they can prove there was like some kind of conspiracy. It's a tool that was used heavily to like roll up the Italian mafia. And civil Rico is pretty similar, right? You're basically arguing like, hey, there was collusion here. There was a conspiracy to do these things, and so we should win money. And you can imagine there can be, especially in retaliation cases, like a conspiracy to isolate someone is something we see a lot. And if somebody complains of sexual harassment or workplace discrimination, you'll see like the whole workplace, like everybody just stops talking to that person. And that might sound silly to you, but the way human beings are built, like all of us, me, you, everyone, you can believe it or not, most of us, I should say, most of us. If everyone in your entire environment just stops speaking to you, that messes with the human psyche a lot. Because back in the day, if you're like hanging out with your village, your tribe, whatever it is, your hunter-gatherer posse, and everybody starts to not talk to you, you're dead. It's over. Nobody's going to protect you. You don't have like a spouse or a mate. You can't collaborate with anyone. You can't go hunting with anyone. You're going to starve. You're going to die. You're just being isolated and excluded. And over the millennia, that fear of that reality has come with us into modernity. And so when the workplace mirrors that behavior, like we freak out almost to the human, like almost all of us will freak out. It's actually pretty horrible. And it's so interesting to watch. And like, I've seen it many times because I do this for a living, and isolation is a common form of retaliation. And you just wouldn't really know what it, like that isolation can do to a human being. Like super successful, super together, super strong, super tough human beings will like freak out as a result of that isolation. So we will occasionally use civil Rico with connection to that. Mississippi 2A guy. Ooh, Second Amendment guy. Hello. Thanks for what you do. I have mediation coming up and your channel really helps me. Mississippi 2A guy. I'm really glad that I help you. I hope so. These videos feel ridiculous to make. I think you can imagine that talking to a camera like this probably feels absurd alone in a room. And a very cold room for the record. I'm wearing my fleece button up today. So thanks for saying they're helpful. It helps me to keep making videos. Gregory Olensky says, what happens after an offer of compromise is offered? There's no response for 30 days. Sounds like you don't have a settlement and your litigation goes forward. Ron DeJohnson says, good day, Vince. Good day, Ron. YouTube user KZ says, defense attorney pulled the mandatory 7-day refusal from age discrimination settlement and is trying to get a court to order me to sign it. Isn't that an illegal agreement? I never agreed to the removal of it. Well, was your claim for age discrimination? So, I'm not going to be able to answer that question because one, I don't know what your claim was for. I don't know what the attorney pulled and didn't pull. If you agreed to a term sheet to settle a case and now you're changing it, they can try to enforce that. There's no guarantee the judge will help them enforce that. But it can be an issue. And if they're like pulling the revocation period, I should say, let's say it correctly, odds are that they think they have legal standing to do that. So I would talk to your attorney about that. Rebecca Baldos says, counsel, can I ask the administrative judge of my case to assist me in my agency complying with the RAC? My agency refuses to observe the RAC and will not answer the appeal I submitted October 2024. I was locked out. So you can go to the administrative judge of your action with anything related to your action. Realistically, if you're going to the administrative judge of your action for something external to the claim that's specifically before the administrative judge, that administrative judge probably does not have the purview to adjudicate that for you. Administrative judge is not like a state court judge sitting on the bench who's just like able to kind of do a lot of things. Like an administrative judge is like very narrow purview, right? That they have very small areas of power. Now, their power is very great in those narrow areas, and they have a great deal of expertise in those narrow areas, but they're not going to like run around being like, you're not complying with this external appeal. Like, it's just not really what they would do. So, long story short, I don't know, but maybe not. Sorry, Rebecca. I wish I had a better answer for you. YouTube user Aristotle Rush says, whoa, chat just jumped ahead. Chat jumping ahead. Okay, Aristotle Rush says, hey, good morning, Vince. I wanted to know how long should it take for a lawyer to go over interrogatories, requests for productions, and requests for admissions after receiving it from defense counsel? Weeks or months? Yeah. So, I mean, it depends. Listen, it obviously depends on how voluminous the discovery production is, but listen, we have received hundreds of thousands and now actually technically millions of responsive pages to discovery on one given case now. And like it can be that much. So listen, I don't know what your attorney received, but like if you have a solo practitioner representing you, it's going to take a while. Now you got a firm like ours. Yeah, we staff up. We get people to code the transcripts. We get people. We get an outsourcing center of trained attorneys to help us review the discovery. We can staff up. I can assign more attorneys to a team. There's a lot of things I can do with a big discovery production because, again, cases are won and lost in discovery, right? Excuse me. And there's a lot we can do for that. But even our firm, like weeks to months, it is not a rapid process. Scott Niebarger says, I raced a Ford Lightning one night while driving my 1993 RX-7. Fun times. Scott, I'm a little ignorant here, but that RX-7, that's a rotary engine. Am I correct? Are you driving a rotary engine from the 90s? And if you are, how much oil does it burn? That's sick. Like, I'm not making fun of your rotary. Like, I am like an enthusiast of the RX-7. I think it's super cool. Rebecca, yes, the caddy. Thank you. Oh, Gregory Alinsky drives an Escalade. Very cool. Gregory. Thank you, Bubblegum, for liking the stream and giving it the thumbs up. I appreciate that. YouTube user John Craig says, my ROI revealed email exchange that HR colluded with the RMO to reprise against me in a discriminatory reassignment case. Can leverage holding HR accountable in a potential settlement talk? Yeah, so that's evidence. You have evidence that helps your case. That is absolutely evidence you can use as leverage in your settlement talks. No question, John. YouTube user Vic says, hi, Vince. The EEOC memorandum is contradicted entirely by the right to sue letter. The memo states that the employer had a viable reason, while the right to sue letter says they cannot say whether or not the discrimination had occurred. Yeah, Vic, nobody, and I'm not like saying this to you, but what the EEOC writes means very little. Like if the EEOC came out and said tomorrow, like if their memo was like, this employer tried to murder Vic, and specifically tried to murder Vic because Vic is a member of protected class and Vic complained of discrimination. And so they hired contract killers to kill Vic. The employment attorneys of the world, both defense and plaintiff side, would be like, oh, EEOC's talking again. Why are they talking? Don't they learn their lesson? Like it just doesn't, it's not relevant. Nothing the EEOC says is relevant. The EEOC exists as a speed bump. You can get some great free discovery at the EEOC level. You can settle cases at the EEOC level. I resolve a lot of cases. Our firm resolves a ton of cases at the EEOC level. Don't get me wrong. But the actions of the EEOC employees, with the exception of processing your right to sue letter, are largely meaningless. Like, and don't get me wrong, there are some great mediators at the EEOC and some awful mediators. And there's some great employees at the EEOC. But the thing that surprises me about your EEOC memorandum is not that it contradicts the right to sue letter. It's that the person who drafted it could read and write, because not all EEOC employees can. So like, I hear you, and it is shocking. Their incompetence is shocking, but not as shocking as I would like it to be. YouTube user Daniel Merrick says, hello, Vince. Hello, Mr. Vince. Cough is sounding better. Thank you, Daniel. I actually just drank some cold brew coffee, which is making my cough much worse in this moment, but generally it is better. We're, I think we get an endoscopy to see what's in my throat, make me cough. We're working on it. YouTube user Bubblegum says, my old employer reached out to my attorney for mediation. Oh, that's great. Congratulations. I hope mediation goes well. They made it clear they will not consider a settlement offer past 5 figures. If they are firm, is mediation worth entertaining? Well, listen, first and foremost, are you willing to take a 5-figure settlement offer? That's up to you. I don't know if mediation is worth it or not. But to your point, I think you're also saying, like, is it worth it to find out information as a fact finding, as a scouting operation? And I would say yes, right? If people are going to sit around and talk about giving you money, go. Have that conversation, or have your attorney go for you. You don't even have to go, right? Give your attorney authority and be like, yeah. Go find stuff out, right? Get in there, kid. Go fight for me, yeah, right? Like, that's what you're getting paid for, attorney. Go, right? So, yeah, I think it's worth it. YouTube user KZ says, funny part of my lawsuit against former employer is for a promised new Escalade per contract. They tried to force that down to a used car with 150,000 miles on it. That's wild, KZ. I hope you get your Escalade. Excuse me. Jerry Horn says, hey, Vince, I received a cause letter from the EEOC preparing for the conciliation. Is there a cap on any award at this level? So, Jerry, if you are only bringing your claim under the federal laws, there are some caps you have to deal with, but just argue that you're also going to be, if you can, depending on where you are, look at whether or not you can argue that you're also going to be bringing your claims under state laws and local laws that may have higher caps or no caps at all. Summer, YouTube user Summer says, are there any resources or textbooks you can recommend for pro se plaintiffs who need to learn discovery approaches rules? I can't go to law school, but I can read the textbooks. Wow. I don't know. I learned discovery by doing discovery as a young attorney, right? Like, so I went in and they just gave me a list of cases, and there was like a paralegal at this firm that I worked at that did nothing but discovery. And like, I went over to the paralegal and I was like, hey, I hear you do my discovery for me. And the paralegal was like, oh yeah, not you. No. I do it for the important attorneys, not you. You do your discovery. Good luck with that. I was like, oh, okay. Well, I've never done discovery. Like, what do I do? And that para was like, you win your case. It's like, you make a list of all the things you're going to want to do at trial, or that you're going to need for your motions or whatever. And you like try to imagine ways to find those things, and one, if they exist, and if they do exist, to obtain them, right? And I was basically like, I remember like looking at this paralegal and being like, okay, that's very general. That makes sense, but that's very general. And I was kind of just like, what's it gonna take for you to like teach me how to do this? Like, I'll buy you things. I'll pay you money. Like what? Like if you're not gonna do it for me, if you only do this for the important attorneys at this firm, and I'm brand new here, like I got to bribe you because I don't know how to do this, and I got to learn how to do this. Like that's how I learned, and like it wasn't cheap. I'll tell you that. And I was not making a lot of money. I was like, I think at that firm I started 32K base, and then a fat percentage of what I would win. No medical, and yeah, I was bribing that paralegal, teach me how to do discovery essentially. So I don't know how you would go about. I'll ask around. I mean, I don't think, if I'm honest, I don't think most law schools really teach people how to do discovery in civil cases. Most of the law professors in law schools are in law schools because they are not competent practitioners. I had some amazing professors. Scott Colasanti, who I had for securities regulation, an amazing professor. But like on average, on balance, 99% of my law professors were losers who just couldn't do the job. And so they were like, gonna teach you how to do the job for, you know, somewhere between like 100 and 300K, which is like a year, which is, if you're like a real lawyer and you're able to do the job, like not a good deal. So yeah, I don't even know where you would go to learn to do discovery. It's almost like an apprenticeship at this point. We have like a forced training program, not a forced training, but our team system ensures that you were on a team with, like, if you're like a first year, a young associate, you're on a team with a senior associate. And on that same team, you have the oversight of a partner, and like they're guiding you and teaching you discovery as it goes, so that you're not in the position or the role like I was of like getting cases and not knowing how to do discovery and then being like, oh, I'm going to have to bribe this guy to like, one, remember my name, but two, teach me how to do this discovery, because if I can't win these cases, I'm not going to make any money, and I got to help these people, and like I got no money, and I was paying rent week to week. That, you know, like I had like a 6 figures in student loans, making base of 32K, hadn't won anything yet, and like I was like figuring out what I could do to get this guy to teach me. So yeah, we have a better system than that for sure. AJ SoFly 69 says the EEOC is still an investigation. Would it be wise for my attorney to contact my witnesses before the EEOC finishes the investigation, just in case? Yeah, absolutely. I think getting certain people locked down to affidavits can be really useful. Also, making sure you know how good your leverage is, how good your evidence is really, you know, really important. YouTube user Elliot Pollock says, Vince White et al. Excuse me, sounds like what the fraternal order of the police do to non-team players, even when they call for backup. Elliot, yeah, that is real. I have represented officers who spoke out, and in so doing, were deemed to have crossed the thin blue line, and there is a real risk for them, and it's sometimes even openly stated that, like, when you call for backup, it's possible nobody will come. You're not liked here. You're not one of us. So you're on your own. And like that can be a death sentence. To your point, Elliot. Like officers who stand up, and I've done a lot of officer on officer sexual assault and sexual harassment and discrimination. Because it tends to be that, you know, some other firms don't want those. And in my youth, I was a bit of a little hard-headed. So I would just be like, well, then I'll do it, you know, like, and those cases can be A little nerve-wracking for the attorneys, frankly, but incredibly terrifying for the very, very brave plaintiffs. Oh my gosh. D. Bentley, thank you so much for the donation. D. Bentley, do you have a question that I can answer for you? I don't see your question, D. Bentley. Thank you. So everyone, please, you don't feel like you have to give me money. I don't do this for money, but I'm going to try to answer as many questions as I can. I've got 28 minutes left to go. But if you do ask a question with your donation, of course, I'm going to try to answer it. Okay. I'm going to try to answer as many as I can for free. Excuse me. All right. What do we have here? Sorry, I'm just looking something up here really quick. I saw one of the questions. Yeah, Rebecca, I'll be honest. I don't really know that much about RAC appeals. I just saw your question kind of went on there. I don't know if they're required to respond to the RAC appeal. I mean, they could just, if they're not required to respond, they could just let it go unopposed and see what happens. Bambito Dadon says, I checked the video. I checked the channel. There's no Civil Rico videos. Okay, I will make you a Civil Rico video. I will put that in the queue to make. Scott Niebarger says, I wish I sold it long ago. Second most fun car I ever drove. Very cool. Daniel Merrick says, what do I need to ask for in my mediation as far as when I apply for a new job that shows I had employment, but does not allow them to say more than I worked there? That's called a neutral reference. I believe you would like a neutral reference. YouTube user Vic says, I cannot say with certainty if the reason to terminate was viable. The EEOC supervisor told me that they are ending their investigation for budgetary reasons, and he didn't review my case in full. Got it. Yeah, I mean, listen, you're going to get a right to sue letter, I think. YouTube user CNote 1906 says, hi, Vince. Opposing counsel submitted a motion for summary judgment for my case in California in federal court. I understand this is standard. Our case is strong, but how nervous should I be? What gets cases dismissed? Thanks. So, I mean, essentially the standard is for summary judgment, that there's not a question of fact. And I'm speaking very loosely here. I'm not allowed to give you legal advice in California. So I'm speaking generalities. In federal court in New York, the standard for summary judgment, which is going to be the same in most of the country, but check with local counsel for you, is going to be, hey, is there a question of fact that needs to go to trial here? So if the evidence as submitted at the depositions and discovery, everything else, the evidential record to date establishes that there is no, oh my God, did we just get a $10 donation? Okay, I will address that in a second. I'm going to finish answering this question. People are big spenders today on President's Day. My goodness. Thank you so much. So essentially the motion for summary judgment standard, is there a question of fact to go to trial? So if the evidentiary record shows that that there's no question of fact, that everything is established and your case could not win on a given claim, then that claim would be dismissed. But now different claims have different things they have to prove, different elements to prove to win, right? So even if one or two of your claims gets knocked out, very likely some of your claims will go forward. I don't know anything about your case. I don't know how your case was drafted. I don't know the situation of the evidentiary record in your case, so I can't say if you have anything to worry about or not. But generally speaking, if you have good counsel, it's unlikely that you would have all of your claims knocked out at summary judgment, unless counsel came to you and said, hey, we're a little worried about this. This is a high-risk claim. Like, things could go wrong here. Or sometimes the evidentiary record comes back and it just doesn't support you. And in those cases, which can be rare, but in those cases, listen, summary judgment can be a risk for the plaintiff. Okay, let's go look at this donation here. Let's go. Okay, YouTube user KZ says, let me first say, KZ, thank you so much for the $10. You did not have to donate to me. As you saw, I've already been answering your questions, but let me pay some special attention to this question. And everyone, the donations are very, very sweet. You don't have to donate. I'm trying to answer everybody's questions. This is just, I guess, I jump ahead because there's a donation here, but I'm not trying to get money out of you. KZ says, yes, Vince, my case involves age, sex, and retaliation as well as fraud. So I would think the 7-day right to refuse would apply to the settlement agreement. Yes. Excuse me. So I would expect that if you have an age discrimination claim, the revocation period would be in play for you. That would be my guess. I don't see any reason why it wouldn't. And based on that, I would think there's a good chance that you would not be held to a settlement based on a term sheet or even a verbal agreement, even more specifically a verbal agreement. Now, in addition to that, let's give you a little extra value because $10 is a lot on a YouTube live stream. If you had a term sheet or a verbal agreement or even an incomplete settlement agreement that was in negotiation, one of the best ways to get out of that settlement agreement is to say, hey, there's terms in this settlement agreement that I did not explicitly agree to, right? And there almost always will be because the term sheet by definition can't include everything. Even a drafted settlement agreement that's incomplete won't include everything the defendants want in the settlement agreement. So you can say, well, hold on. I did not potentially, hypothetically, if there's no in the term sheet language about confidentiality, non-disclosure, mutual disparagement, things of this nature, right? You can say, hey, hold on. You're adding things. One of the most important things to me as a plaintiff KZ, was to speak out and to share my tale of woe, the way I was treated, right? Because stories are how we advance society. The story is how we advance as a people and become better, right? Stories can change hearts and minds in a way that a case, the whack-a-mole of litigation, can't. So I didn't want to execute this agreement because now these assholes threw in some confidentiality language that wasn't in the term sheet, Judge. And so I don't think I should be held. To this settlement agreement. That not perfect. I'm not saying it's get out of jail free card. It is still possible that you could be held to your settlement agreement. But speaking in generalities, not giving you legal advice wherever you are, but in New York and the various jurisdictions where we've had that argument, where we've made that argument, I have never seen a judge say, nah, I'm going to hold you to settlement. Never once. Now, every time my own attorneys in my firm will say, like, listen, there's no guarantee, Vince. There's no guarantee we're going to get away with this argument. Fair. Sometimes you can get held to a settlement agreement. That can happen. It happens. I'm just going to be clear, though, KZ. When making that argument, I've never personally seen it happen. Not once. Not saying that means it won't happen to you. Not saying that's the only argument. Not saying you only have to make one argument. I'm just saying if that's viable in your situation, it could be an argument that you'd want to make. Okay? All right. We have a $9.99. People are spending money today. My goodness. Okay. Let's like this here. YouTube user The Truth says for $9.99. Hello. I was accused based on 2 forged, backdated, handwritten documents. My name is not mentioned in the documents, but I was fired. I received the rights to letter, looking for contingency lawyers. Okay. So YouTube user The Truth. You are going to have an EEOC filing. The original filing, the position statement, the rebuttal, I presume. Sounds like you went through the full EEOC process. I would put that together as a package. I would hit up our YouTube playlist, how to find an employment attorney, and also how to evaluate employment attorneys. And I would craft the most compelling package for your case that you possibly can. I would even, and I've made a video about this, but I saw somebody do this recently and I thought it was really, really smart. They put together an EEOC package, the original filing, position statement, the rebuttal, a couple key pieces of evidence, and they filmed a YouTube video, which they left on private, but private that, like, if you sent the link to it, people could see it. And they were going around to firms with the package, going to intake, being like, here's my case. Here's a 1-minute video about my case, in which they do 2 things, right? They explain the case, but they also show you, hey, this person communicates well. This person is going to make a good witness. This person's compelling on the stand. They're a good communicator. They connect with their audience. The video was clean. It was nice. That full package made completely in line with our playlist on how to find an employment attorney, how to make it compelling for employment attorneys. That is your best bet. Excuse me, for finding full contingency representation on a federal litigation. In my opinion, that is my best advice that I can offer. Now, listen, if you're trying to get us to take your case, I don't do that on live streams. You can talk to our intake people. This is meant to be free help. This is supposed to be us giving back. So like, this is not how I find cases for our firm. Although people do often contact our firm through the YouTube channel. That's not the point, right? But that is what I would do. YouTube User the Truth to help you or to recommend to you. Let's make my cough worse with cold brew. All right. Who's next? And also, thank you so much for the very generous donation. Okay. Chat kind of has jumped along. I've lost the thread here. Maggie Zarkio says, is it possible for an ROI to be provided in pieces instead of one PDF? I don't fully understand why you would care if it was one PDF, but you can, if you have Adobe or some other piece of software, just break up the PDF into multiple pages so you can share only the parts you want. Or if you don't have those programs, you can print out the PDF and scan only the pages you want to share and make that a new file. I'm not like an IT expert, but like very, very easy to do. All right. YouTube user Jesse Manuel says, I wrote a complaint about a manager to HR on January 17th. I worked on the 18th and had 2 days off, the 19th and 20th. Caught the flu, took the 21st and 22nd off, came back to work on January 23rd, and I got fired. Retaliation. So, yeah, that's probably retaliation if your complaint engaged in a protected activity. So if it was about discrimination, sexual harassment, unpaid wages, yes, retaliation. Excuse me, or something else that would give rise to retaliation claim. Excuse me. YouTube user VA says, hi, Vince. Is it retaliation when a former employer threatens to sue you because your attorney sent them a demand letter saying, in effect, settle now or we'll go to trial? Yeah, I would think that's retaliation. I think you can certainly argue that's a retaliation, an act of retaliation. YouTube user Rico Marshall says, if you had to pick one field of law to recommend a student considering law school, what would it be? Rico, what's the goal? Is your goal to turn time and attention and irrational aggression into money? Employment law, without question. Like, there's not enough employment attorneys, not even close. One moment. Yes, I mean, if the goal is to make money, employment law without question. And it's not like there's not more lucrative fields. There is. Like, I worked in investment banking, straight out of law school, lucrative field, not gonna lie, but like, there's such a dearth, a lack of qualified employment attorneys in this country. And there's no lack of investment banking and mergers counsel. So if you go into like some kind of investment banking law, mergers and acquisition, you have to vie to get those jobs. Those are lucrative jobs. Don't get me wrong. They're great. I mean, I was working in an investment bank during 2008, and they came to me like, hey, you're going to be one of the ones we keep. We are going to cut your compensation in half. Now, notably, cutting my compensation in half was still viable. It was still pretty nice, right? That's wild to think about, right? So I'm not saying it's not a well-compensated field, but I am saying it's very, very easy to become an employment attorney and spend a very brief time, 1-2 years, working at firms to learn more about the industry. excuse me, and then start your own firm and be a millionaire in 2 years after you start your own firm. That's very achievable if that's something you want. And if you want to help people along the way, you're sure helping people. Like, that's no doubt. You don't get paid unless you help people. So, like, fulfilling, lucrative, terrible quality of life. A lot of employment attorneys don't last. I have videos on the channel about this. Unbeknownst guy says, how hard are appeals? Super hard. When the judge submitted wrong dates, mischaracterization, misapplication of law, applied the date of December 21st in filing a EEOC complaint when they were filed in April of 21. Thoughts? Okay, so listen, I'm not appeals counsel. You need a viable grounds for appeal. And typos or mistakes of fact are not necessarily going to give rise to that. Now, mistakes of fact that fundamentally change the way the decision should have gone will generally give rise to a viable grounds for appeal. So, excuse me, I can't really answer your question. One, because I'm not really appeals counsel, but two, excuse me, we need to know all those mistakes. Should they have changed the decision? You know, had the judge gotten those facts and dates correct, should the judge then have made a different decision? And that's the question. Okay. YouTube user Rhonda Johnson says, would it be helpful to use a defendant's EEOC position statement against them in court if it contains lies that can be exposed? Yes. Yes, it can. Sorry, I drank too much coffee and the acid in the coffee is making me cough. Ron, yeah, absolutely, it can be. Specifically, you can use it for witnesses when they say one thing and you're like, well, in the position statement, you were quoted as saying the exact opposite. So which is it? You can see the power there, right? It can be pretty valuable, certainly. BMCK says, as a pro se, I filed a motion for attorney representation. It was denied by federal court judge. What might be an effective next step for me? Do I need the judge permission to hire a limited scope attorney? No, you don't need the judge's permission to hire an attorney. It sounds like you made a motion for a free attorney. That's how I'm understanding your question. And if you're in a civil case, that's generally not going to be granted, right? You have a right to representation. Excuse me, if you were being accused of a crime, like the court has to get you an attorney. And there's other fields too, like somebody's going after your kids, something like that. You might get a free attorney. But if you're the plaintiff suing someone for money, you're not gonna get the same level of service from the government. They're not going to pay for the attorney for you in most cases. So if that's what you're asking for, I'm not surprised they didn't give you a free attorney, but you absolutely have the right to hire an attorney to represent you. YouTube user Ray Hilsa says, hello, Vince. Should every individual that is named in the complaint be identified as a defendant? No. Every individual you want to sue. The defendants are the people you're suing. There can be lots of people who show up in the complaint who did bad things, but you're suing the employer because they're the ones with deep pockets, right? And everybody else is working for the employer, presumably, so you just have to sue the employer. Now, you can sue other people. There's reasons. We have videos on the channel about why you might want to include individuals for liability purposes and drive wedges between parties and stuff like that, but that's a more subtle distinction and strategic question. YouTube user AGG Town says, I never signed a company rule book. My employer forged my signature with my e-signature from when I signed up for the company third-party payroll. I have Questco email that correlates with the date. Got it. You might be surprised. In most cases, the company rule book and whether you signed it or not is not all that meaningful. It doesn't mean it's not in yours. I don't know the specifics of your case, but generally speaking, there's a lot of clients, a lot of plaintiffs who are very concerned about whether or not they signed the company playbook, rule book, a handbook, whatever it is. And most of the time, the perspective of the attorneys is like, yeah, don't care too much. Not really a big part of the case. YouTube user, hey, daddies. Hey, as in like grasses, dried. Daddies says, pro se in the West, 5th, Tennessee 5th. Any advice? Strong evidence of retaliation for causing compliance while on FMLA. So you provide the index number for your case. Not going to lie to you. Not going to go look that up. But that being said, you have an FMLA case. FMLA retaliation claims. Listen, I like FMLA retaliation claims. I think they can be really valuable. Try to find other people. So your case often, often FMLA cases will be won and lost in discovery. So one thing is, if they're doing it to you, they're probably doing it to other people who seek FMLA as well, the Family Medical Leave Act time, right? So try to search in discovery for similarly situated peers who are treated in the same fashion, and their cases can support you, but also check the docket for other FMLA cases against your employer, because then you can find a ton of evidence in those cases and it can really help your case. What do we got? Okay. YouTube user. Okay. Whoa. Chat jumped ahead. Let's go back. Let's go back. Let's find it. Oh, Hey Daddies sent us $2. Hey Daddies, thank you so much. Did I answer your question? I hope I did. Yo, you guys have given so much money. This stream doesn't even tell me when you give me money anymore. It's like overwhelmed. D Bentley gave us $1.99. My gosh. D Bentley, where's your question? D Bentley, I have to find your question. Oh, here it is. Thanks for everything. I have a fact-finding court date on the 27th. My job fired me for going to the emergency room. Any tips? I have to drive 77 miles to and from the job. I'm a CNC machinist in the aerospace industry. They wouldn't take my question. You have a fact-finding court date on the 27th. So you have a fact-finding conference. Is it before the EEOC? So you're saying your job fired you for going to the emergency room. So one thing I want to firm up there is, can we characterize your trip to the emergency room as being caused by a disability? Because if we can characterize your trip to the emergency room as being caused by a disability, any disability will do, as long as it's qualified under federal law and potentially the state and local laws where you are, then we activate the disability discrimination laws. And those can be a lot more powerful in many jurisdictions than the sick leave laws, right? So I don't know where you are. Aerospace industry, I feel like you might be in Texas or Florida, but I don't know. So we'll just pretend you're in New York for a minute so I can give you an example. If you have like a sick leave, like you're like, oh, I took sick time to go to the emergency room, and you get fired in New York City, there is a sick leave law, but essentially you're like bringing that claim to get your job back. Now, getting your job back is not nothing. It can be really valuable. But if you instead were able to argue, hey, I had a disability, I had to go to the emergency room, and I was fired for going to the emergency room for my disability, sure, you also have that claim for the sick leave law. You've got federal claims, state law claims, and New York City claims, all for disability discrimination. And those claims don't just try to get your job back. They try to get you fat checks. Not as fat as they should be, but still fat checks, right? So now you're bringing a claim, not saying, please, can I have my job back? You're saying, hey, yeah, I would like my job back, but I'd also, I don't know, I feel like I have a demand for a couple $100,000, and that's a lot more leverage. You're much better positioned to bargain from when that's your claim, right? So, D Bentley, that would be ideal. Okay, we have 4 minutes left. 4 minutes left. I'm going to scroll, and we got really busy today. I did not expect it to be so busy today. This chat is no longer telling me when you all give me money, so I'm going to scroll through the chat and try to make sure that I'm not ignoring anyone who gave me money. We have 70 concurrent viewers and only 36 likes. It is free to like the stream, people, and does help the algorithm. So before I go off air in 4 minutes, I'm going to scroll through this chat to make sure that I have not missed any of the paid questions, because people have given a lot of money and I don't want to ignore anybody. And anyone If I miss a question that you paid for, please email me and just be like, hey, I'm so-and-so from the live stream. I gave you this amount of money. Can I get an answer video? And I'll make you an answer video because I feel terrible that I'm like missing. For whatever reason, the chat's not telling me if people pay me money anymore. Okay. All right. I think we may have answered all of the paid questions. Deep Bentley, you gave me money twice. My goodness. I hope I give you value. All right. All right. So we have 63 concurrent viewers, 45 likes on the channel. I'm going to go to the end of the stream. YouTube user by his grace says, I did a FOIA request with the EEOC. Do you know what items they will only release to you? I've asked how many open cases they have towards my ex-employer, and they denied me from that ask. They denied you about how many cases against a given employer? Oh, you asked how many cases. You didn't ask for the case files. So I would recommend, by his grace, that you try again and you just ask for the case files. That's what I would recommend. Because I do not, I'll be honest with you, I don't have trouble getting that information. I don't know why they denied you. Might have been the phrasing, might have been that you asked. It sounds like you may have asked them to create an answer for you, which they don't have to do. But if you ask for the file or pre-existing documents, that is something they probably have to comply with. I recommend that. Okay. I got to go pick up this truck. New truck Monday. Sorry, the live stream was kind of short. Oh, Ivy Mike 551 says, what would you say if you send blatantly clear direct evidence to the other side? They don't. Oh, somebody just gave me $10. Why are you people giving me so much money? Okay, Ivy Mike, what would you say if you send the blatantly clear direct evidence to the other side and they don't respond at all to the atom bomb and they demand you drop? Like, there's no refuting your claim when considering the evidence provided. So listen, they might think that you're not going to go on to federal court, or they might not agree with you as to the quality of your evidence, Ivy Mike. Or listen, they could be tactical. They could just be trying to get a cheap settlement, right? Okay, Ryan, or what YouTube user Rye H asked us, got fired for refusing someone to do someone else's job, a job I did for years, and I complained to HR. Also finding that my personal inventions were stolen. Okay. So, Rye, that does not give rise to any discrimination or sexual harassment claims, which is generally what we deal with on the channel. But I feel like there's a larger conversation here, and I have to log off. So what I'm going to do, Rye, is I'm going to respond to your chat with my email address. And everybody else, do not email that address. But Rye, I feel like there's a lot going on here. It sounds like you have some IP issues. I might be able to refer you to an intellectual property attorney if they stole your inventions. Like, I want to give you some value for what you sent, over. Also, like, listen, there's a conversation. Why are they trying to have you do other people's jobs? Is there discrimination going on? Is there retaliation? What specifically is happening here, right? Like, I want to drill down for you so you're actually getting value. And also, your inventions are valuable. Like, that's your intellectual property, your blood, your sweat, your tears, I presume. So, like, let's see if we can get you intellectual property counsel who can take a moment out of her or his day and advise you about that. I want to make sure you're getting helped. All right, everybody. Spirit Driven says, I definitely screenshot that email address. Spirit Driven, I'm going to be upfront with you. I don't actually peruse that email address. Like, people review that email box, but I'm putting a note in the system so that Rye H will get through the filter, essentially. So Spirit Driven, don't misuse that email address. Okay, everybody, like, subscribe, comment down below, share the channel so it can grow. Thank you so much. I'm sorry I only went live for an hour today. I gotta go pick up this truck. I gotta get this truck so I can feel like I'm successful. Because I'm a sad little man, as we know, right? All right, take care, everybody. Bye-bye.